and making decisions in our best interest. It is such an important day for us as a family because my youngest son, it will be his first opportunity to be able to vote and to exercise that right. But back to why we are here this afternoon. You are being hosted by the Dullah Umar Institute for Constitutional Law, Governance and Human Rights, and they are based at the Faculty of Law here at the University of the Western Cape in South Africa. At the time, Advocate Dullah Umar, a human rights lawyer and a lawyer for the former President Mandela, who later became Minister of the Justice of the Democratic South Africa, he was the first director of the original center here at UWC. And that law center played a major role in the negotiations towards a democratic South Africa. So how opportune that this is the discussion that's happening here today on this heroic or strategic day for us here in our country. Ever since its inception, the Dullah Umar Institute has been a major contributor to policy formulation for South Africa's constitutional order and increasingly elsewhere on the continent. So the topic you are discussing today, dealing with climate change, is of critical importance. Since yesterday, world leaders are meeting in Glasgow at the COP26 summit, which will bring parties together to accelerate action towards the goals of the Paris Agreement and the United Nations Framework Convention on Climate Change. Recent research shows that children born in this decade are 7 times more likely to be exposed to extreme weather events such as heat waves, flooding, and wildfires than children who were born 60 years ago. Just here in my own country, just 2 months ago, here in my own town where we have never experienced snow, we actually got to touch snow. That is how extreme global warming has become in our countries. With global warming, extreme weather conditions will continue to intensify, putting more children at risk of being affected mentally and physically. Undoubtedly, the climate change crisis is a child rights crisis. You know, a couple of years ago in our country, here right in the city of Cape Town, we had our fair share of the negative effects of climate change. We were dealing with the country was at the point, or the city was at the point of running out of water. It was at a time where there were conversations and plans made to understand how would this affect households, because households had to be rationed with 25 liters of water per day. In a city where we're used to abundance, suddenly there was a scarcity. This was a crisis which demanded that we sit around the table and discuss how do we manage it. More so, how do we manage it for a sustainable future? And that, I think, is the most important part of what we are wanting to do. Therefore, for me, it is no surprise that we have seen a great interest in this webinar hosted here today. There were quite a few people registered for the webinar, and I'm sure more people will join as we go along. People from various countries, yes, in Africa, Botswana, Lesotho, Ethiopia, Kenya, to name but a few, and then more internationally, such as Mexico, Italy, Japan, Denmark, Switzerland, Belgium, Germany. Yes, all over the world, people have connected to come and have a discussion around climate change. This just highlights for us the importance of this global challenge and what it means for all of us in our various contexts. So this afternoon, the objective of the webinar, I think, and Prof. Mesmer will expand on that, is to get the circle bigger. We like to say that here in South Africa, let's make the circle bigger. Let's get more people talking about it. Let's share collective ideas to find solutions to something that is not only unique to a certain part of the world, but it's a global challenge for all of us. So in the words of lawyers, to make this jurisprudence on climate change and children's rights well known, let us reflect on where we have come from and what we have experienced and learn from it as we move forward. So to this afternoon, as I welcome you and invite you to enjoy the discussions, I want to wish you good deliberations and may we find solutions to a challenge that is troubling us worldwide. Be welcome. I thank you.
Thank you very much, Professor Franz, for those words, but also for bringing a personal touch to it. I vividly remember a few years ago, when day zero was what it was being called, when the city was actually to close off the taps, and we were told that we were going to line up in what they called PODs, points of distributions, where we were to receive 25 liters of water per person. And the average understanding was there would be 4 individuals per household. It was a scary moment. It was actually getting too close to home. And many people in different ways are experiencing the negative impact, as you have clearly highlighted. So we really, really appreciate you taking time from your day off. And I know you said you voted, and I felt comfortable to ask you, to invite you once I established that you voted, because I don't want to violate another important aspect that is taking place here in the country. So thank you very much. So we can proceed. Thank you very much again. Now, from my side, I'm not going to be long. When we planned this event, we called it "Looking Back to Look Ahead." In fact, the initial title had "Looking Back and Sideways to Look Ahead." Why sideways? Because as a treaty body, the UN Committee on the Rights of the Child doesn't operate in a vacuum. It operates in a system. We keep on talking about the human rights treaty body system. So it should be able to compare notes, to look sideways, to see what is happening in relation to this topic or a related topic within other treaty bodies. I can promise you that, and my colleagues that are here on the call, Professor Skelton, our chairperson, who I would like to recognize, Ms. Mikiko Otani is also here. We have had conversations where we said, can we look at the jurisprudence from the InterAmerican Court? Can we look at some document from the Inter-American Commission? Or can we look at what has been done in relation to case X from the Human Rights Committee? So it's not just only to look back, to look ahead, but we're also trying to look sideways so that there is some cross-fertilization, there is some lesson and purpose in moving forward. The second point that I think I should mention is, I will be very honest with you, when I had this discussion with the potential speakers, the intention, as I'm going to say now, is not really to defend our position as the UN Committee on the Rights of the Child. Absolutely not. That's not the intention. The intention is to put it out there. Just before we started the conversation, I had a brief side chat with Helen, where she said to me, and I hope you can forgive me for saying this, Helen, where she said to me, it's actually a good practice that we should, some of the other treaty bodies should also open this up for a discussion and to learn from it. I'll be honest with you, the decision was made on 11 October. We learned, and I personally can confirm, I learned quite a lot in the process. And even after the ruling has been made, I have continued to learn quite a number of things from what is written in the media, what is written in blogs, what has been tweeted, and maybe one or two of you might come to a couple of tweets. Surely in the discussions, I can come to a couple interesting ones that I found. So we thought the conversation can benefit from not the relatively rigid United Nations processes, the conversation that we often have, Your Excellencies, and with member states and so forth. But we thought it would be useful to have these conversations with academicians, those people who roll up their sleeves and work on this issue on a daily basis. We had the intention to have a civil society organization, particularly one that has been involved in exhaustion of local remedies related issues. We haven't succeeded to do that, but honestly speaking, I feel comfortable because I can say a few words, and I'm sure from the floor we can get some reflections about some of the challenges, but also the opportunities pertaining to exhaustion of local remedies. And I have no doubt that the speakers that we have on the panel will draw the attention of the participants to some of those important issues. Now, having said this, we have, as I said, we have excellent panel with us today. I will introduce each one of them when I give them the opportunity to make their interventions. But let me just say a few words about the case. I can safely assume that most of you have had the opportunity to look at the case, what it's about, and what it actually brings to the fore. But I don't want to take it for granted, so let me just use a few minutes and say a few things about the case. I vividly remember, like it was just a couple of weeks ago, in September 2019, my colleagues and I, we were in session in Geneva, and we knew that this was coming. And there was a press conference that was convened by UNICEF and the lawyers for the children and the children as well, which we were very grateful about, that we had the opportunity to hear from the children, even from the start of the press conference. So they said, in response to the escalating climate challenge or climate change, 16 children from around the world, including actually from here in Cape Town, because one of the complainants, Ayanka Melithafa from Erst River, is actually here in Cape Town, not far from where I live. They filed a petition with the UN Committee on the Rights of the Child against Argentina, Brazil, France, Germany, and Turkey. Now, I know the media has picked this up quite a bit, even at that stage, that Greta Thunberg is one of the petitioners. She's doing an amazing work. She's championing this cause left, right, and center. Of course, we're very grateful to her, but it's a whole range of children, not just only those that are involved in this case, but also throughout the world, in four corners of the world, that are actually facing the challenge, but also pushing the boundaries to make sure that leaders and countries actually honor their commitments as far as climate change is concerned. The main claim that they brought through the communication is the following: that by failing to prevent and mitigate the consequences of climate change, the state parties have actually violated the children's rights under Article 6, that is on the right to life, survival, and development, Article 24 on the right to the highest attainable standard of health, Article 30 in relation to indigenous children, and of course, this should come as no surprise, Article 3 of the Convention on the Rights of the Child, which deals with the best interest of the child. They claim that by causing and perpetuating climate change, the state parties that I've mentioned have failed to take necessary preventive and precautionary measures. And I emphasize the word precautionary here because the precautionary principle might be something that we can come up to later on in the discussion. Precautionary measures to respect, protect, and fulfill the author's rights to life, health, and culture. They claim that this is something that we have seen in many reports that have come in recent years. The most recent one being the one by UNEP last week. And I understand, I haven't had the chance to go into it in detail, but I understand the title is "The Heat is On," which is a true reflection of what is happening in our world. They say that the 1.1 degree centigrade rise in global average temperatures is presently causing devastating heat waves, fostering the spread of infectious diseases, forest fires, extreme weather patterns, as Professor Franz said, floods and sea level rise, and a very long list of human rights violations of millions of individuals all over the world. And often children find themselves at the receiving end for a number of biological, social, legal reasons. Now, in relation to one of the aspects, in relation to best interests, for instance, they said that, which is very important, they say that their complaint actually documents the violation of their rights under the convention, but they said the scope of the climate crisis should not be reduced to the harms of a small number of children, not just the children that were actually before the committee in relation to this communication, but they said that the effect and the negative implications are actually much, much wider. And they said at stake are the rights of every child everywhere. And rightly so, because the climate change crisis is not bound to country X or small island states only, or those that have a seashore and so forth. It's relevant from, as I often say, Afghanistan to Zimbabwe. It's from A to Z. And there was no illusion in the communication that has been brought before the committee. Of course, the committee, before deciding on any case, and this is not peculiar to this case, in relation to any communication that has been brought before it, it needs to decide on admissibility. So from the admissibility conversation, there were arguments, and I'm not going to be able to go into the details here, but there were arguments that said that, for instance, Argentina said that the communication is absolutely generic and legally indeterminate. So that is one of the arguments that they mounted and said that this is inadmissible. They also said that the communication is inadmissible ration loci, because in relation to the authors who are not nationals of the state party, because as you can see, there are 5 cases that we have decided on. So they said, in relation to the authors that are not nationals of our state, we're not going to be bound, and there is inadmissibility argument that can be launched in relation to ration loci. They said that that as a state party, they acknowledge the existence of international obligations of an extraterritorial nature, as well as the possibility of transboundary environmental damage, which I hope we can come to when we proceed further, because it was one of the central elements that were covered by the Inter-American Court's advisory opinion. They said that they considered that this is not the case in the communication that we're dealing with. There were arguments that were mounted in relation to inadmissibility, ration tempori, for instance, as the events that were being alleged took place before the coming into force of the optional protocol in relation to a specific country. But make no mistake about it, the main argument by all states parties that was made very forcefully related to the issue of exhaustion of local remedies. All the state almost argued and said that this communication has been brought before the UN Committee on the Rights of the Child without testing the existing local remedies that were available. There were a number of conversations. There were conversations whether or not the specific legal system could provide effective remedies, whether or not it could be unduly prolonged, whether or not the complainants, even though they are not nationals of that specific state, could actually access local remedies within the jurisdiction. There was even conversations about legal aid. What is the extent to which legal aid will be available? Will it be available only to nationals? Will it also be available to non-nationals? There were even conversations about COVID, the extent to which COVID has actually served as a barrier to bring these cases to court, and particularly during the oral hearings as a committee. And I'll be very honest with you, it's for me as a member, but as Biniam generally, it was one of the right decisions that we made in relation to this case, which was to allow oral hearings from the parties. Because to have things written on paper, as compared to have it on paper, but also hear directly on a conversation basis, on a dialogue, not a monologue, it's not a one-way traffic, on a dialogue basis, to hear from the author, to hear from the states. And of course, we also had the opportunity to hear from the third-party interveners. That was the right decision that we made. So from the exhaustion of local remedies conversation, we heard a number of arguments. There were arguments, for instance, in relation to one of the state parties, whether or not the different options that they have in their constitution, in their legal system, would be adequate, whether the kind of remedy that is being sought by the complainants would be addressed through those legal systems, whether or not legal aid was available, whether or not COVID had affected their process and so forth. And the state parties also brought their counter arguments where they actually highlighted some of the points pertaining to exhaustion of legal remedies. Now, the case, of course, addresses three specific and very important aspects. The first one pertains to jurisdiction. Whether or not the committee actually has the jurisdiction to deal with this case, and given the extraterritorial nature of some of the allegations, and also given the fact that climate change is something that almost every state contributes to, whether or not the committee would have the jurisdiction. So we looked at a number of elements. For instance, we looked at the principle of common but differentiated responsibility. Some of the arguments that were made by the state parties was the argument that actually said, we're not the biggest emitters, whether you look at it currently or whether you look at it historically. As a committee, we concluded that the state parties had effective control over the source of emissions that contribute to the causing of reasonably foreseeable harm to children outside of their territory. And we needed to determine whether there is a sufficient causal link between the harms that were alleged in the communication by the children and the state parties' actions or omissions, as the case may be. It's probably a combination of both, for the purpose of establishing jurisdiction. And we moved on to the issue of victim status, which you can see as having a specific section in the decision. So we looked at a number of elements. We looked at the allegations about the right to life and culture and health and extreme storms, flooding, and so forth. We looked at all those elements. And as a committee, we concluded that the authors, on the basis of this, just the documentation that has been submitted, but also from the hearing, have actually sufficiently justified, again, and I want you to mark my words, for the purpose of establishing jurisdiction, that the impairment of their convention rights as a result of the state parties' acts or omissions regarding the carbon emissions originating within their territory was reasonably foreseeable. And we concluded that prima facie, at least, the authors have established that they have personally experienced a real and significant harm in order to justify their victim status. And of course, the third element, as I mentioned earlier, was the issue about exhaustion of domestic remedies. And again, as I said, we had quite a lot of conversation about what could potentially be available. What is the case law to support the argument that says, you know, the authors could have actually approached the domestic courts in relation to this case. There was an argument, for instance, pertaining to foreign sovereign immunity that would prevent them from exhausting domestic remedies. As a committee, we said that we note the issue of foreign sovereign immunity that may arise only in relation to a particular remedy that the authors would aim to achieve by filing a case against other respondent states parties together with the state party in its domestic court. And as a committee, we consider that the authors have not sufficiently substantiated their arguments that the exception under Article 7E, unduly prolonged or ineffective and so forth of the optional protocol, that the application of the remedies is unlikely to bring effective remedies. I have seen some arguments that were made in writings in terms of blogs and so forth, which seem to suggest that was the committee worried that if it did allow these cases to proceed to be declared admissible without exhaustion of local remedies, that it would undermine the legitimacy of the mandate that the committee has, the legitimacy of the optional protocol, even future possible ratification of the optional protocol, because currently it stands at 48. I will be very honest with you. The number of ratification was hardly the consideration. It was not a consideration at all. But whether or not allowing these cases without the complainants going to the domestic sphere, for example, the case of Germany was straightforward, but a number of others were less straightforward. But ultimately, we arrived at the conclusion that there was a need for the complainants to actually go at the domestic level and test the availability of domestic remedies. As a committee, we noted the author's argument that pursuing remedies in the state parties would, for example, be unreasonably be prolonged. We noted the few examples. There were a number of examples of environmental law cases in the respective state parties, which our attention was drawn to them, saying that they have taken several years and that they do not provide any further specific information on the length of such proceedings in the state party. That was also noted. And we noted that the state parties, all of them, provided examples of environmental litigation in which cases were resolved within a reasonable time frame. What constitutes a reasonable time frame? What constitutes unreasonably prolonged? This is something that we can have a conversation on. But in relation to the case that was before us, we were convinced that exhaustion of local remedies was not undertaken. It was not even tested, particularly with the mounting evidence from all the 5 states where litigations of this nature were already underway or were already decided upon. The example of Germany is a good example again here. We couldn't actually go beyond declaring admissibility, and we couldn't go beyond finding jurisdiction, which we believe is already significant, but we couldn't see ourselves declaring that without at least testing the circumstance at the domestic level. We were not able to proceed further as far as exhaustion of local remedies is concerned. Now, having said this, as I said, during the discussions, we can come to some of the aspects pertaining to the case. The next speaker that we have is Professor John Knox. He's an internationally recognized expert on human rights law and international environmental law. And of course, he's the former special rapporteur on human rights in the environment from 2018 to 2018. He was the first independent expert and then ultimately the first special rapporteur. He is currently the Henry Lohmann Professor of International Law at Wake Forest University in North Carolina, where he teaches and writes on human rights law, environmental law, and their relationship with one another. He was one of the third-party interveners, and it's an absolute pleasure to give him the opportunity. Over to you.
Thank you so much, Professor Mesmer, and thank you to the University of the Western Cape and the other organizers for inviting me to participate. Thanks also to the Committee on the Rights of the Child, the members, for all of their work in this area, all the work that they've already done and all the work that they're going to do in the future, because this is going to be something they continue to work on, I think, for a long time. I'm also going to keep my remarks brief. I just want to say a few words about the implications of this case for climate change litigation generally. So to provide a little context, I think it's important to note at the outset that there is a huge amount of rights-based environmental litigation going on right now. Excuse me. That litigation takes place at the domestic level in national courts. It also takes place at the regional level in front of tribunals like the African Court on Human and People's Rights and the European Court of Human Rights and the InterAmerican Court of Human Rights. And then, of course, it also takes place at the international level, the global level, before treaty bodies like the Committee on the Rights of the Child. Much of this litigation, I think it's important to understand, is based on human rights other than the human right to a clean, healthy, and sustainable environment. But I think it's important also to note that that right was just recognized for the first time by the United Nations less than a month ago at the Human Rights Council session, which adopted a resolution recognizing for the first time that the right to a clean, healthy, and sustainable environment is a human right. But even in the absence of a global treaty that already recognized that right, people have been making arguments for quite some time now about how environmental harm interferes with human rights and how human rights obligations on states require them to take measures to protect against that harm. This has been particularly important in the context of climate change. As I don't think anyone in this audience needs to hear, climate change has been, I think, extremely poorly addressed by most of the countries in the world. We're nowhere near where we need to be as a global society on addressing this gigantic problem. I'm optimistic that the COP going on right now in Glasgow will be a step forward, but I think we should all be realistic about how slow that process has been and unfortunately will probably continue to be. So in that context, litigation to try and move states to move more quickly, to move corporations to move more quickly, has turned out to be extremely important. And recent decisions in this regard, famous decisions, include the one by the Dutch Supreme Court in December of 2019 in the Urgenda case, the decision by the High Court in Germany in April of this year in the Neubauer case, both of which essentially ordered their governments to move more quickly to reduce greenhouse gases. But there are a very, very wide number of decisions, not just in Europe, not just in the global north, but important decisions all over the world, certainly including the global south. At the international level, in particular, there are pending decisions right now before the Human Rights Committee, which Professor Tugruja may say something about, although she'll be limited in what she can say because they're still deciding it. There are also pending cases before the European Court of Human Rights, one, for example, brought by Portuguese youth against essentially other countries within the European court system. So the important thing to realize is that there's a kind of exploding jurisprudence here, and that these cases, these tribunals, courts, quasi-tribunals, treaty bodies, and so forth, are in a kind of dialogue with each other. As they're addressing these new issues, they look to each other to learn how other courts have addressed them, and then to contribute to that ongoing dialogue themselves. And we're going to hear shortly from Soledad Garcia Munoz, who's going to describe one of the most important decisions in this area, the InterAmerican Court's advisory opinion, which the Committee on the Rights of the Child draws on in its own decision. So that's just one example of how these decisions interact with each other. And so in that respect, I think it's important to realize that the committee's decision is going to be one that other courts, other tribunals, other treaty bodies look to. So in what particular respects are they going to look to? Let me just highlight 3 or 4. First, I think it sends a message that at the international level, at the United Nations level, the human rights treaty bodies are open to receive climate cases. Treaty bodies had not decided a climate case before this. They had started to decide more and more environmental cases. The Human Rights Committee that oversees the ICCPR has decided two just in the last 2 or 3 years. And as I said, they have one on climate pending, but this is still the first decision by a treaty body in a communication on climate. Treaty bodies have already been addressing climate issues in their joint statements and country reports and work like that. But still, it sends a message, I think, to other potential litigants that the communications procedures will be open to hear climate cases. Now, you might think that this point is contradicted by the fact that the committee, in fact, as Professor Mesmer just said, found the communication inadmissible. But that kind of leads me to my second takeaway, which is that the treaty body sent a strong message that it won't short circuit its normal requirements and procedures, which include requiring local remedies to have been exhausted. In other words, as important as the climate crisis is, obviously, the committee still sent a strong message that you still have to follow the procedures that are required for communications to be brought here, and we can't relax those even in this time of crisis. I'm not going to go into detail on the committee's reasoning on this. Obviously, the petitioners disagree with the conclusion, and David Boyd and I, who filed a third-party amicus, we supported the petitioner's position on this, that remedies would be futile. But as Professor Mesmer said, there certainly are a lot of cases being brought domestically, including in Germany, one of the respondents. So the committee's decision is essentially one that looks at that body of domestic law and says, you have to try your domestic courts first. Having said that, this is not some kind of new requirement that the committee just came up with. Exhaustion is one of the oldest requirements for bringing claims. It exists in every international system in one way or another, or virtually everyone. And so holding that it has to be met, in my view, certainly will not prevent future cases from being brought. I expect to see, again, many more cases, but I think it will, let's say, focus the cases that are brought more on the ones that have been unable to find relief domestically. Now, a third kind of takeaway from this is the committee did reach very important points that it could have chosen to avoid. In other words, once the committee decided, well, exhaustion of local remedies hasn't been satisfied here, it could have issued a fairly short decision to that effect. But it was very significant that instead it addressed some of the other objections states have made to admissibility. And in my view, two of the aspects of its decision are particularly important. One is what it said about extraterritorial obligations of states. The optional protocol on individual communications to the Convention on the Rights of Child says that communications may be submitted by or on behalf of an individual or group of individuals within the jurisdiction of a state party, claiming to be victims of a violation by that state party of the rights in the convention. So the question here was, were all these petitioners within the jurisdiction of a state party? The respondent states pretty much all said they were not, except for the occasional petitioners who happened to be from their own state. So Germany, for example, said basically you can't hear a case brought by people outside Germany. France said something similar. And so the committee's rejection of that, I think, is quite important. And it did it, I think, in a very rigorous way. And it doesn't take anything away from their rigor to say it essentially borrowed a test from the Inter-American Court of Human Rights that was adopted in their advisory opinion. But it's still a test that, as David and I argued in our amicus brief, is consistent with that used by the Human Rights Committee and other human rights tribunals. And the test, in the words of the committee, is that when transboundary harm occurs, children are under the jurisdiction of the state on whose territory the omissions originated if there's a causal link between the acts or omissions of the state in question and the negative impact of the rights of children. So there's a requirement of causality. Second, the state of origin has to exercise effective control over the sources of the omissions. And third, the committee says the alleged harm the alleged harm suffered by the victims needs to have been reasonably foreseeable by the state at the time of its acts or omissions. So while, as the committee notes, some of these elements have to be really addressed in more detail when you get to the merits, even at the stage of admissibility, you have to show essentially a prima facie case on these points. And significantly here, the committee found that all three of the elements were met. It said the state does have effective control over the admissions because it can regulate them. It also, in that context, included some really important language on the responsibility of states in relation to a global problem. It said, even though it is a global problem, that doesn't absolve the state of its individual responsibility, which is a really important point to make. The committee also found that the harm was reasonably foreseeable. There's a lot of scientific evidence on this. And it found that there was enough of a causal link based on the petitioners' submissions about the harm that they felt. So this, I think, is extremely significant because it sends a message, again, to future petitioners that if you have exhausted your local remedies, or you can really show that they would be futile, then we are open to hear cases. Of course, you still have to show us that you succeed on the merits, of course, but we're not going to rule out the case simply because some of the petitioners are from outside the territory of the state. So let me say, I'm just about out of time. Let me say a couple of words about how I think this influence will be felt. I think you can think about it kind of radiating out in concentric circles. First, very importantly, this decision, I hope, will inform the future work of the committee itself, which recently announced that it's going to be issuing a general comment on environment with a particular focus on climate change. Second, I hope that it will provide a useful precedent for other treaty bodies and other members of the UN human rights system, such as special rapporteurs. And in this respect, I note that the Human Rights Council last month also decided to appoint for the first time a special rapporteur on climate change and human rights. So this is the kind of decision that can go to inform their work. Third, I think it's going to be really interesting to see how this will influence other international bodies. In particular, for example, there's a pending case before the European Court of Human Rights, as I said, which in many ways raises many of the same issues. It's also brought up by youth who did not exhaust their local remedies first because they said it was futile. And it's, even though the youth are in Portugal, they're bringing a case against many other states. So it raises questions of extraterritoriality. And then finally, the farthest influence perhaps is on national courts. But I don't want to suggest that that means that national courts won't be paying attention. I think many of them will. The Urgenda case, after all, is based on the European Convention on Human Rights, and it very much took into account the jurisprudence of the European Court of Human Rights. So again, this dialogue that I referred to is very much taking place between domestic and international courts as well. So I'll just close with that and say, I expect this will be the first of many, many more cases like this to come at the international level, and it's one of a greatly increasing number of cases at the domestic and regional levels as well. Thanks again, and I look forward to hearing what other people have to say about this.
Thank you very much, Professor Knox, for those inputs. Very much appreciated, but also for the positive view about moving forward. I agree with you that you supported the complainants as a co-third-party intervener and so forth, but I'll be very honest, some of the media conversation, particularly, you alluded to it, the human rights lawyer at the law firm Horsfield that actually represented the children. One of the comments was, this was a deeply disappointing dereliction of the committee's duty. I'm not quite sure. There have been conversations whether or not the committee actually closed the door. We actually left it open. But again, these points will probably even be further built upon in the inputs that will come. I'm glad that you also came to the extraterritorial issue, and we have our colleague from the InterAmerican Commission who we relied quite a bit on the Inter-American Court advisory opinion, and we will get the opportunity to unpack it a bit more in moving forward. But again, thank you very much for that positive outlook, but also the way forward in terms of how things will potentially develop. The next speaker is Professor Helen. She is currently a member of the UN Human Rights Committee. I can confirm that we actually looked at jurisprudence from the Human Rights Committee. She's currently a senior global fellow at the New York University School of Law, law professor at Aix-Marseille University in France, co-director of the law school's master program of international law, and director of the summer school on practice and human rights, and expert on preparations before the International Criminal Court. She has conducted research and taught in various universities. She enthusiastically accepted the invitation, similar the way Professor John Knox and the other panelists did. So we're absolutely happy to have her here. So the floor is yours. Over to you.
Thank you, Benyam. Thank you, Professor Mesmour. Yeah, no, I was really enthusiastic because, of course, as an academic, and I'm speaking as an academic to this event, I'm following the work of the CRC, and I have to say that it's one of the most interesting treaty bodies, especially in terms of new approach to children's rights and human rights, and I will allude to this in my presentation. And also, I think, as I said before, when we discussed, indeed, for me, it's really a good practice to have this kind of discussion on views adopted, because in general, we adopt views in Geneva. It's a quite close place, and we do not have, except in some academic events, we do not have the opportunity to discuss between treaty body members and about the positive aspect, the less positive aspects. So I think it's really a good practice, and I'm really happy to have the possibility to share views. I would say from the Human Rights Committee, but again, I'm talking as an academic and not as a member, as an official member of the Human Rights Committee. So maybe some elements on where we are at the Human Rights Committee in terms of environmental questions and climate change, and Professor Knox already mentioned this. Of course, your views and your position in these different views are consistent also with the general comment of the Human Rights Committee 36, and especially paragraph 62, where the Human Rights Committee stressed, and I'm quoting, that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generation to enjoy right to life. So it means that we are on the same page. And as Professor Knox said, it's always very important to send to state parties to the Convention on the Rights of the Child and the ICPR the same message. And the message is clear. Climate change, it's, of course, as you said in your views, it's a children's rights crisis, but it's also a human rights crisis. So we have a consistent message, I would say, both the CRC and the Human Rights Committee. Your views are also, I think, in terms of methodology, and it's really something I appreciated in the different decisions. Your views are consistent with our it's a growing approach, but it's not the traditional approach of the Human Rights Committee. I mean, the methodology of quoting other treaty bodies, regional bodies, and so on. And for me, before entering the Human Rights Committee, I was really appalled by the fact that in general, the Human Rights Committee did interpret the ICCPR totally in isolation, without quoting anyone else or without quoting another treaty body, regional courts, and so on. And now it's a new approach. It's always a point of discussion between members, but it's really something that is moving in the practice of the Human Rights Committee. And in your decision, it was excellent. It was absolutely excellent because you really, as you said, Professor Mesmour, at the beginning of your presentation, you say, okay, we cannot interpret the CRC in a vacuum. And indeed, you you analyzed the different positions adopted by the Human Rights Committee on Jurisdiction, for instance, or the Inter-American Court of Human Rights, and you decided your own position based on this international landscape. And for me, from a theoretical point of view, as from a practical point of view, of course, it's really important because most of the time, state parties criticize international human rights law because it seems to be very fragmented and so on. And your decisions illustrate quite the contrary. Of course, we have plenty of different positions on this question of climate change and different approach to jurisdiction, different approach to exhaustion of domestic remedies. But you did not ignore this different approach, and you decided your own position based on this international landscape. So I think it's also a very important input of your views, and I really hope that other treaty bodies will more and more use this dialogue, inter-treaty bodies dialogue, but also dialogue with regional organs and with, when relevant, with a tribunal organ. And on this topic of climate change, and I agree with what was said before, on this topic of climate change, of course, the CRC and the Human Rights Committee, I would say, paid the same kind of tribute to the contribution and the leadership of the Inter-American Court of Human Rights. So it's quite clear that when we talk about environmental law at the international level, climate change, states' obligation, and especially extraterritorial states' obligation, we have a clear leadership from the Inter-American Court of Human Rights. And now your decision is really has used this approach of the Inter-American Court of Human Rights to put this, I would say, at the universal level. So it's absolutely, for the Human Rights Committee, it's also a source of good practice that we could follow. Maybe on the two more challenging point, I would say, of the cases, as you explained, I can share the discussion before the Human Rights Committee, the topic of jurisdiction and the question of the exhaustion of domestic remedies. But on this, I would have more a question for you, that's a strong position. I would say that we have the same problem. The Human Rights Committee has the same problems and is facing the same problems when we have cases of dealing with extraterritorial jurisdiction. And what was quite interesting in the views against France, in your views against France, what was quite interesting is that France, as a kind of defense, repeated that it was totally opposed to any form of extraterritorial jurisdiction, and France reaffirmed also its opposition to the General Comment 36 on the right to life, especially on this extraterritorial aspect of notion of jurisdiction. So the Human Rights Committee is also struggling on the good definition or the renewed definition of jurisdiction. So there was, at the beginning of this year, in a different context, we adopted an AS versus Italy decision on a search and rescue responsibility operation, and especially the responsibility of Italy in this search and rescue operation. We used some criteria to establish Italian responsibility and Italian jurisdiction over the fact. They are a bit different, I think, than the criteria you used in your own definition. But for me, the interest precisely of your views is that I have the impression that you are more precise. We adopted in this search and rescue case, we adopted a definition of jurisdiction, but very frankly, and we can see this with the different dissenting and the concurring opinion. There was a lot of discussion among members. There was a lot of opposition on the best way to establish this jurisdictional link and how to define jurisdiction. So as Professor Knox said, the interest of your own views on this question is that maybe you provide, I would say, more clarity on how to establish jurisdiction, especially when we have this extraterritorial dimension of a situation and so on. But I have to say that it's also, so I would be very interesting, of course, I respect the principle of confidentiality of your discussion, internal discussion, but I would be very interesting also to hear about the general discussion you had, because for the Human Rights Committee, it's still a moving question, a controversial question, and we are 18 members, and I'm sure that we have almost 18 views on how to establish jurisdiction. And as Professor Knox said, for us, it's really a practical question also, because we have pending cases with this extraterritorial question, not only on climate change, but again on the search and rescue operation and so on. So I was really interested by your views, and I would be also interested to hear perhaps more on the discussion you had. There is another question, maybe, of course, the decisions are not decisions on the merits, but I have a question also for you. I do not know if you considered to analyze this case jointly, because of course we have this shared responsibility question when we talk about climate change. And in this case, of course, it's clear that we have a problem of shared responsibility. I raised the point because when we discussed the cases on search and rescue operations, we discussed also this aspect of, internally, this aspect of shared responsibility. Now I arrive to the question of non-exhaustion of domestic remedies. Indeed, I perfectly understand, and here I'm talking as an academic, because I'm sure that probably the Human Rights Committee would have followed your approach of to this question of exhaustion of domestic remedies. But maybe my point as an academic, my point of surprise is that when you addressed this question of jurisdiction, you borrow the interpretation of the InterAmerican Court of Human Rights and this innovative and creative approach to jurisdiction. And I was surprised that you didn't do the same for exhaustion of domestic remedies, precisely because in the jurisprudence of the InterAmerican organs, and Soledad, of course, would talk much more than better than I'm doing on this jurisprudence. But when the organs, the InterAmerican organs, do address exceptional circumstances, specific circumstances, they accept exception to exhaustion of domestic remedies. So my question is whether you had this discussion about how to also maybe modify this approach to exhaustion of domestic remedy that is a very traditional procedural requirement before lodging a petition to a universal or regional body. It's true. So I'm not saying that when we talk about climate change, we have to forget these procedural requirements, but we are in very exceptional circumstances with very exceptional claims. So is this old traditional diplomatic protection rule still relevant when we talk about transnational global problem and global questions as climate change? So I had the impression that maybe it was a missed opportunity also from the CRC to elaborate a bit more on the exception. But again, here I'm talking as an academic because I'm sure that we will also face this kind of procedural requirement, and I'm not sure, I do not know how the Human Rights Committee would decide. My final point, my final words are really similar to what Professor Knox said. For me, it's absolutely true that your views are going to influence at least international organs, so regional. We have talked about the European Court of Human Rights and the Human Rights Committee. I do not know how it will influence the Human Rights Committee and the European Court of Human Rights. I mean, I do not know whether we are going to, or the European Court of Human Rights is going to follow your approach to jurisdiction, and I have some doubt, especially based on the recent cases of the European Court of Human Rights on jurisdiction and the different position of the CRC, for instance, on repatriation of children, and the position of the European Court of Human Rights. So I do not know if we can reconcile the regional body and the CRC, but for the Human Rights Committee, it's absolutely true that at least we will draw inspiration from your views. So thank you again. It was really a pleasure to read the views, absolutely creative views. Thank you very much.
Thank you very much. Rest assured that all the conversation is academic in our personal capacity and not on behalf of the, as I started the conversation, I said that this is not an official Committee on the Rights of the Child, the UN event. No, absolutely not. So you can rest assured about that. The second is, yeah, very interesting questions. I can give a couple of points there, but my colleague, Professor Skelton, is also here. My colleague, the chairperson, Ms. Otani, is also here. They should definitely feel to weigh in the conversation. I don't want to preempt anything from the input that Ms. Soledad is going to bring, but just to mention that we had quite a bit of a discussion about we had a bit of a conversation internally about the rescue at sea case. That the Human Rights Committee had a number of opinions that were shared, and in that context, we had a conversation whether or not are we opening it too wide, it is principled enough, and we concluded, and of course the Inter-American Commissions, the Inter-American Court on Human Rights advisory opinion, where the notion of significant and significant harm was elucidated in more detail, which we could borrow from, was definitely very useful. But it will come from the discussions, and I'm happy to jump in, but of course my colleagues will also weigh in. The next speaker is Ms. Soledad Garcia Munoz. She is the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights. I was excited to know that it's not just only, I'm just only learning in the process. I didn't know that the Special Rapporteur had specific reference on environmental rights, so we're very, very excited about that. So from the Inter-American Commission on Human Rights, OAS, she has provided professional and voluntary services to different agencies of the UN, to Amnesty International, the Ibero-American Youth Organization, among other prestigious organizations that I won't be able to do justice to. Before her tenure as Special Rapporteur, she was the regional representative for South America of the Inter-American Institute of Human Rights based in Montevideo, Uruguay. She also enthusiastically accepted the invitation to join us here today. We're absolutely grateful for her time, but also her colleagues who've been very instrumental to facilitate this. So it's over to you.
Hi, good morning, good afternoon, or good evening, everyone. Thank you very much, Professor Mesmer and all the organizers for this kind invitation to allow me to talk about how the Inter-American human rights system have served as a reference in the case brought before the Committee of the Rights of the Child. It is a great pleasure for me to participate in your event with such distinguished colleague. It has been extraordinary to hear the important reflections from the three of you, Professor Chiguda, Knox, and Mesmer. This case not only demonstrates how international human rights protection mechanisms can address climate change implications, but also how different systems of international protection of human rights can dialogue with each other in order to attain a more complete protection of rights. So I will first point out a brief history of how the Inter-American human rights system addresses issues pertaining to environmental degradation within its different mandates. Afterwards, we will dive into the implication of Advisory Opinion 23/17 of the Inter-American Court, which is quite cited in the decision by the committee. And finally, I will refer to some of the steps we are undertaking in Redesca to include climate change in the agenda of the Inter-American Human Rights Commission and system. First, let me share that Redesca, that means a special rapporteurship on economic, social, cultural, and environmental rights. But we use the acronym in Spanish, Redesca, always, is the second special rapporteurship created by the Inter-American Commission on Human Rights in its entire history, and the first mandate of the Inter-American human rights systems that, as you very well said, explicitly recites the mission of promoting and protecting environmental rights and develop standards related to climate change. We work on the mandate from a holistic and indivisibility approach that involves all the economic, social, cultural, and environmental rights. We also put the gender and intersectional perspectives at the center of all our tasks. We work for the right to water, sanitation, health, food, housing, environment, education, labor and union rights, etc., as well as on central themes for economic, social, and cultural rights, such as business and human rights or the fight against poverty. Of course, we work taking into account the interdependence with civil and political rights, considering the right to life as a central right and belonging to both civil and political rights, such as economic, social, cultural, and environmental rights. It was wonderfully stated by the judge Antonio Cansado Trindade in his reasoned vote in the Villagrán Morales case, Niños de la Calle versus Guatemala. The Inter-American human rights system is not a stranger to environmental issues to be part of the core issues that it has had to deal with. However, through his history, it has had an indirect approach towards its protection, putting first rights such as life or personal integrity in order to tackle environmental harm. The system has not taken a case based solely on non-compliance with the right to a healthy environment, but has rather taken other rights associated with it, such as the right to participate in the decision-making process or to access information in environmental matters. Hence, cases like Clor Reyes versus Chile or Sarayaku case versus Ecuador from the Inter-American Court have cemented the basis to discuss both issues within the framework of the Inter-American system. However, the Commission has also been keen to bring forth the human rights implication of environmental degradation. For example, within the scope of its monitoring duties, that is one of the pillars of the mandate of the Commission explored this matter first when analyzing the situation of human rights in Ecuador in a report in 1998. Afterward, it has also overviewed this matter in its annual report. First, in 2015, when the Commission included a brief study of the right to water within the Inter-American system, and later in 2018, when it included a section to only analyze the situation of the right to a healthy environment in each country of the Americas. Additionally, the Commission has also held a series of thematic hearings regarding the protection of environmental defenders the right to a healthy environment, about the extractive industries, and the implication of access rights in environmental matters. However, it is valid to note that the Commission has also taken climate change head-on in several instances. First, on a hearing in 2007 regarding global warming and human rights, followed by a hearing on 2011 pertaining to climate change and access to water. Then in 2019, under the auspices of my mandate, the Commission hosted a hearing regarding climate change and the economic, social, cultural, and environmental rights of women, children, indigenous people, and rural communities. More recently, last week, concretely, the Commission held an historic hearing to investigate the implication of extractive industry in the Caribbean and the effects on climate change and human rights. You can watch this hearing in the website of the Commission. It was really an extraordinary hearing, and I think it's opened the door, the window for new developments from our part. Also, in the report, Business and Human Rights, InterAmerican Standards, prepared and published by my office in 2019, with the vision of inter-Americanizing the issue and reading the guiding principles of the United Nations from the perspective of the Inter-American system, we dedicated a special section to the issue of climate change and the obligation of the American states in the matter. This report identifies the fundamental Inter-American criteria on business and human rights, one of which is the right to a healthy environment. We also clearly established the extraterritorial obligation of states on the matter. So this report is also a valuable tool for climate action under the Inter-American system. This notes that the Commission has been continuously advocating to include the environment as the main part of its agenda. Furthermore, with the creation of Redesca as a specialized office, it has grown its interest and reach to give weight for an ample discussion on this issue. As such, the climate emergency and its impact on economic, social, cultural, and environmental rights, mainly on the right to water, is a priority, is a top priority of the strategic lines Redesca is undertaking in our strategic planning for the current mandate that expires in 2023. I also would like to highlight the work of the working group of the Protocol of San Salvador, which is in charge of measuring the progress of the member states based on a system, a really sophisticated system, an innovative one, of indicators that include the right to the environment recognized in Article 11 of the Protocol of San Salvador, additional to the American Convention, as you certainly know. I am a member of the group on behalf of the Commission, and I have just assumed its presidency, and the working group is made up of 5 experts who I hope can also contribute significantly on the subject. And nevertheless, I would like to close on how important Advisory Opinion 23 from the court it is, not only for the Americas, but for international protection of human rights and the environment worldwide. As an active actor of the Inter-American system, let me begin by congratulating and acknowledging the importance of centrally citing the Inter-American Court in the committee's decision. In the committee's decision, the advisory opinion is cited first in the aspect of jurisdiction, particularly referring to transboundary environmental damage. And in that sense, the committee notes that the exercise of jurisdiction arises when the state of origin exercises effective control over the activities that cause the damage and consequent human rights violation. For this reason, the committee considers that the test applied by the court is the most effective, since it allows for the committee to consider that while the required elements to establish the responsibility of the state are rather a matter of merits, the alleged harm suffered by the victims needs to have been reasonable, foreseeable to the state party at the time of its acts or omissions, even for the purpose of establishing jurisdiction. For this reason, the committee also takes on the analysis of the court on what other duties the state should have for it to further comply with its obligation. In this matter, the committee stressed that the court finds that the obligation to prevent environmental harm is recognized by international environmental law, under which states may be held responsible for any significant, this is a key word in the advisory opinion, significant damage caused to persons outside their borders by activities originating in their territory or under their effective control or authority. This consideration from the court do bring certain elements to further the scope of analysis. The committee has to present that the jurisdictional claim does fall into the competence of this body. However, it is also important to consider that the opinion of the court does also advance other ideas that cement the autonomy of the right to a healthy environment on its own. Especially when we read paragraph 62 of the advisory opinion, the court does clearly state that the right to a healthy environment does not only protect the interest of the person in its connection to the ecosystem, meaning that this right is also aimed at protecting the environment by itself, even if it does not have any direct impact on the well-being of a group or people or an individual. It actually calls for the protection of all the elements that make up an ecosystem, including its air, soil, water, and natural cycles, and connect the advisory opinion also with the important and crucial debate of the rights of nature that are recognized in several Latin American constitutions of the Bolivian or Equatorial. The advisory opinion is a trailblazer in the Inter-American system that is constantly inspiring the Commission and my office develop new standards in this matter. As such, Redesca is currently working in developing a standard focused mainly on the impacts of climate change on human rights in the Americas from an intersectional and gender perspective, noting that even in the opinion does give a solid groundwork for environmental protection promotion in the system, there is still much to do, especially in relation to climate change. So we are moving forward in drafting a new resolution for the Commission on climate change and on the emergency climate change. Is that we had a very, very interesting exchange with the Commission, with the plenary of the Commission last week, and they agree with us that the current wording to use is emergency and not just crisis. And as of 2017, surely you know the system has begun a new stage characterized by enabling the direct justiciability of economic, social, cultural, and environmental rights through Article 26 of the Inter-American Commission. The first case in which this occurred was in Lagos del Campo versus Peru on the right to job stability. In February 2020, the court issued a judgment in the first case in which the right to a healthy environment is declared autonomously violated. In the case La Cajonta, Nuestra Tierra versus Argentina. Thus begins a new and promising stage in the justiciability of the environment before the Inter-American Commission and courts. The Inter-American Commission is the gateway, as you know, to the complaints that reach the system, and I trust that we will soon be able also to analyze a good case on climate change. The decision of the Committee of the Right of the Child has important elements for our analysis, and I am sure that it will also be cited by the Inter-American Commission and Court in its resolutions. The Saachi case opens important horizons for climate litigation, also before Inter-American human rights bodies, where the season of cases and petitions is of high impact and recognized for its reparative capacity in the face of human rights violation. Our region is the most unequal on the planet, in which the richest countries coexist with the poorest. Two of the three most affected by climate change in the world, Haiti and Puerto Rico, are in the Americas, where the Caribbean and Central America are increasingly affected by global warming. We don't have time to lose to work to protect the rights of children and of the most vulnerable population in the face of climate change, starting with the 209 million people living in poverty in the Americas. So welcome, very welcome to this exchange and all the alliances that we can build in this meeting. Thank you very much for your attention.
Thank you very much. That is very, very well received. No doubt that a significant amount of work is actually being done by the regional systems, and in this particular case, the Inter-American system. I myself come from the regional system, and I know quite a bit of the work that is being done by the African Committee of Experts, but more importantly, the African Commission on Human and People's Rights, including on exhaustion of local remedies, but of some of the jurisprudential guidance that is being given. And thank you for welcoming our ruling. Also, the relatively good reliance that we made on the Inter-American Court's advisory opinion. So we definitely welcome that. Okay, so let's open the floor for a conversation. I know that there have been some points that were raised. I have seen one or two. For instance, there was a question from Nimrud, which said, what political considerations, if any, go into decisions like this, considering that you'd like to have a ruling that is legally legitimate, but also practically enforceable. It doesn't say who this is for, but anyone from the panel can come to it. But of course, in relation to this decision, I can definitely reflect on it. Does anybody want to come before I do? Maybe Professor Helen, you want to say, for instance, from the Human Rights Committee's experience, but I will say in relation to our own decision if need be.
Thank you. Yeah, it's always the question of legitimacy. It's always, and political legitimacy. It's always a very tricky question because, again, we are 18 and we do not have the same perception of what is a legitimate decision. Of course, not on a legal basis, we are on the same page. But when we talk about legitimacy, it's legitimacy for the states, or it's legitimacy for civil society, or for the victims. And in general, it raises a lot of interesting decisions because we have indeed precisely this kind of debate. And okay, but if we adopt this decision, the states will not be happy, or if we adopt this decision, victims will be extremely disappointed. So for me, this political dimension may be very tricky to solve because, of course, it's difficult to offer a satisfactory decision for different stakeholders. So that's also the reason why I would have a very formalist answer, but it's also important when we are not sure to reconcile different stakeholders. It's always important to try to stick on the legal reasoning and to try to provide the most relevant legal reasoning. The practical element on the implementation or not, for me, it should not be a consideration because if you adopt, and again, we have different views among members of the Human Rights Committee, but if you have a look, if you at the very beginning of the process, if you have this consideration on how the decision will be received by the state, will be implemented by the state, for me, it would lead to a very self-restraint from the body, more or less as the European Court of Human Rights is doing. okay, is my decision or would my decision be accepted by the states? If not, okay, I'm not going to adopt a very creative interpretation and so on. And I prefer the methodology of the Inter-American organs that really stick to the interpretation of the American Convention, the pro victima, the pro persona approach. And okay, maybe states disagree, but it's not the purpose of a human rights body to always adopt a decision that would be considered as good for state, because states would accept to implement the decision. So I do not know if I respond to the question, but it's really an important question. And in general, this political dimension is important in the decision-making process. I have to say, I mean, I have to admit, we are not purely legal mind.
Thank you very much. I will say in relation to this decision, as far as our process is concerned, but I'm going to give the opportunity to Ms. Munoz or Professor Knox, if you want to give a stab at this. I'm not putting you on the spotlight. If you prefer, you can come to the next opportunity as well.
Something very short, because I think everything has political implications in every aspect of our lives, not just in the protection of human rights. But I think it's very important to defend and put at the center the autonomous character of the human rights bodies in this context, and that will be my reply. Of course, everything has political implications, but we are talking about bodies that are independent and that function autonomously than the states, and that are considering question, taking into account the international framework. And that should be central, I think, also in criticizing the decisions of a body, the consideration of its autonomy and its independence. Thank you.
Thank you very much. Professor Knox, if you want to come in, fine. Otherwise, I will.
Well, maybe I'll just say I think it's important to bear in mind that the committees, the treaty bodies, have different roles in different functions. So in other words, I think it's one thing when a treaty body, for example, is interacting with the state as part of that state's submission of its report, when there's a kind of a combination of considerations, including good practices, the cooperation of the state with the treaty body and so forth. From a perspective of a special rapporteur, it's different when we're, say, on a country visit and we're interacting with a country that, may be interested in moving more towards compliance with various obligations, but also moving beyond that towards good practices. I think in my own view, I think of that in a different situation than in a situation where you're actually trying to say what the legal requirements are. And in these kinds of submissions under the various optional protocols to treaty bodies, then I think it is. I mean, I would agree with Professor de Gruja. I think there should be less room for political considerations if you're asked what the law is on something or how the convention applies in some area. I think it is appropriate to be more formal in your response because, that's kind of how the system is set up to provide a formal legal answer. But fortunately or unfortunately, one way or the other, I've never been in a treaty body, so I haven't had to kind of grapple with these issues from that perspective.
No, thank you very much. That's very useful. Let me just say a word or two on this. As you rightly said, when we're dealing with individual communications, we're actually sitting as a quasi-judicial. The process is a quasi-judicial process. So there are a number of predetermined legal criteria that are actually required to be complied with. So that's a very important departure point. Now, secondly, it's absolutely important because in this particular case, we did oral hearings and my colleagues, Professor Skelton and our chair, Ms. Otani, can confirm this. We did actually meticulously planned the process. to make sure that there is no imbalance or an appearance of favoritism, as it were, because I clearly remember that we gave enough amount of time to this and enough amount of time to the other one. It was timed, every I dotted and every T crossed, and that was an absolutely important aspect of this. Now, I have seen, and I was asked last week as well, I will come to what I was asked last week, but I have seen some blog articles that actually, which I alluded to earlier at the beginning when I mentioned whether or not the committee had a bit of a hands-off approach on the issue of exhaustion of local remedies, because it didn't want to affect the issue of ratification. I beg to differ. Absolutely not. In fact, we have heard, I previously was coordinator of the working group, I have heard in a number of occasions where some states are worried about some aspects of the optional protocol. For example, the optional protocol becoming almost a first port of entry for family disputes, you know, a husband and a wife and marital affair related issues and so on. And they have not, there is some information that says, I don't have the data to back it up, that says, you know, some states are reluctant to have a hands-off at this point in time because they want to see how the jurisprudence in relation to a specific theme is emerging. The example that I just gave you. So we've heard that generally in the context of lobbying states to ratify and so forth. But when we're dealing actually with an individual case, a real case, that is not a consideration at all. Now, that's the political aspect. But to what extent will it be practical and so forth? Last week I received a question. Interestingly, this panel would have been complete, I promise you, even maybe more complete, if we had the opportunity to bring someone from one of the states, a state representative, to actually give us that side of the conversation. But last week I had the opportunity to, in the context of something else, to have a conversation with one of the diplomats in Geneva, who happens to be from one of these states. And he specifically raised the question, why didn't the committee consider the possibility of an amicable settlement in the case? You know, my response is, at least based on my experience from the regional body at the African Committee of Experts on the Rights and Welfare of the Child, the treaty body can offer the possibility for an amicable settlement, but you would have generally a sense of something that can be settled amicably. If the arguments on the parties are actually North Pole and South Pole, and they almost become almost irreconcilable, it's usually very difficult to do an amicable settlement. Last year, I had the opportunity to seek for an amicable settlement involving the government of Sudan in the context of armed conflict in the Sudan and complainants. And from the get-go, it was possible to see that there was quite a bit of concession from the part of the government, that they wanted to improve a number of elements, and an amicable settlement would not have led to grave violations or irreparable harms being done, or it would not have been irreconcilable with the mother instrument that was being handled. But in this particular case, this is just my view, not necessarily a committee view. And as I said, it was raised by one person based in Geneva. My view was that from what I saw as a member, it was not something that could potentially come in the amicable settlement process. One additional point that I want to flag, and it's something that I've mentioned to colleagues, a few months ago, we had a session, we had a panel like this one involving the issue of climate change. And Professor Knox would probably know this, because there was a momentum that was being built up to make sure that the resolution at the Human Rights Council could succeed. And one of the briefings that I received for that panel said, please, as much as possible, say as little as possible on litigation, on climate change related litigation. That I can understand. You know, it's a strategy. You have member states and so forth, so you don't want to scare them. That's a valid consideration, but not really in the context of a quasi-judicial process that we're actually talking about at this stage. I have seen one question in the chat from Masarat. It said, given some data that shows that many domestic cases decided neither mention the CRC nor are decided in favor of complaints involving children, could this not serve as a ground for exception to the local remedies rule? Professor Knox, this might come across as being part of the conversation that we had in the context of the third-party interveners, but anyone who would like to, because there was some information that actually said, and I can definitely give this a jab as well. There was some information that actually drew our attention to the fact that there were about 1,800 cases that have been looked at in the previous whatever years where domestic systems were not in a position to make decisions. They didn't make reference to the convention or the general principles of the convention, or were not necessarily decided in favor of children, and whether or not this would actually qualify or this would have been instructive to the committee to say, okay, because of that reality, we can actually allow an exception to local remedies in this case. Professor Helen, if you want to come in the context of the Human Rights Committee, would this be an argument that would carry the day, or Ms. Soledad, anybody? And as I said, I can also weigh in.
No, maybe not in the context of the Human Rights Committee, because again, I think we would have adopted in this specific case the same approach. We are really, especially in this new composition of the Human Rights Committee, extremely cautious on domestic remedies and so on. But I agree. I'm taking the example of France and the French defense in this case. Maybe my regret is precisely that the CRC did not go deeper in the analysis of the success prospect of the French of the different French avenues the French government put forward in the claim, because I'm precise for the participants that I'm French, so that's also why I'm more familiar with the French system. I do not think actually that the different French avenues put forward by the French government are really have a chance of a positive chance of success. And indeed, one of the remarks in the chat, indeed, in France, in general, the CRC is never applied. The only provisions of the CRC used by French domestic tribunals are Article 3 on the best interest of the child, and maybe in cases of deportation, Article 9 on family reunification. But that's it. In France, we have almost no application of the CRC. So maybe there was a room for me to give substance to this exception to the exhaustion of domestic remedy again in the French context, I would say.
Thank you very much. Yeah, any of the other panelists? Okay, can I just say a word on this? This was one issue, as I mentioned, that our attention was drawn to. But again, it's a quasi-judicial process. The exception to local remedies we're very much aware of, and in fact, in our jurisprudence, this is something that we will continue to explore. One of the biggest challenges pertaining to this case was that there was not even an attempt. So there was no attempt that was actually made to exhaust local remedies. As I mentioned, there were some arguments in relation to being futile or not being futile. We spent quite a bit of time. You can see in the decision that we actually spent a substantial amount of time dealing with exhaustion. There were some arguments in relation to legal aid. There were some arguments in relation to COVID, and so forth. But at the end of the crux of the matter, and I say this partly, I remember how passionately the issue about exhaustion of local remedies was debated during the negotiations. This is actually one of the areas where states have drawn a red line on. We don't want. I mean, I can safely say I don't want this process to be a first port of call, undermining the possibility for exhaustion of local remedies being tested at the domestic level. That's one. Secondly, potentially appearing as though we would be going beyond our mandate as a committee, unless and otherwise there was clear evidence that this would actually fall within the exceptions. Now, in relation to the specific question, the counter argument would be there are cases after cases after cases at the domestic level that the state's parties drew our attention to, but that we're also aware of, even if it's not in relation to these 5 countries. There are a number of other cases outside of these 5 countries as well, but we're talking about this case that actually showed that at least there should have been a conscious effort to test the waters, because with no effort, otherwise it became theoretical, that you're just looking at it and saying from a distance, I'm not quite sure whether this will succeed. So just on the basis of my mere doubts, as the jurisprudence from the Human Rights Committee clearly says, I'm going to see how this will proceed. One positive thing that we have seen, and this is something that I picked up from the media, that colleagues and we managed to see from the media, is that the complainants, I actually want to quote that before I move to the next question. The complainant's lawyer, in one of the complainant's lawyer actually said that they will go and taste. Yeah, this is what it says. It's from an article from The Guardian, and I quote, "In the future, if these children or other children supported by the," okay, this is from our side. Okay, so this is what the complainant said, and I quote, "Doing what the committee said these children need to do, exhaust domestic remedies, means spending years litigating these issues on appeal, facing reversals until finally coming back to the UN and bringing exactly the same case that was filed in 2019, he said. And again, quote, "Only this time the evidence will be even worse. The threats will be even greater, and the failures of these respondent states to take sufficient action will be even more pointed." There is positive news there that hopefully they will actually go to the domestic sphere, but it's also the point that Professor Knox made earlier, that hopefully the domestic courts are also paying attention to what is happening at the United Nations level, that it would hopefully have some positive effect on the ground so that it can actually improve the lived reality of children at that space. Let me go to another question, if you permit me. This is from Harry Balfour Lynn. "Thank you for this fascinating discussion. I'm interested in the implication of the Saachi et al. Case for the recent Parliamentary Assembly of the Council of Europe proposal for a new protocol to the European Convention on Human Rights on the right to a healthy environment. When this right has been proposed for the European ECHR framework in the past, the response of the Council of Europe states has been that a broad environmental right would not be workable within the European legal framework. They point to the entrenched jurisprudence of the European Court on jurisdiction, quality of victim, causation, exhaustion of domestic remedies, etc. Do you think that the Saachi decisions reflects new possibilities for flexibility on these sorts of questions?" Who wants to give this a shot?
Yeah, I can maybe. Hi, Ari. Thanks for your question. On quality of victim, yeah, probably. Yeah, we could consider that the European Court of Human Rights would follow the same, because the European Court of Human Rights has a very broad, or may have at this admissibility stage, a very broad interpretation of quality of victim. On jurisdiction, I have really doubt, and again, I have doubt, especially in light of the very constant and reaffirmation of position of the European, even recently, position on the European Court of Human Rights on jurisdiction. And there is actually, as you may aware, as a member of the CRC are aware of, there is a contradiction in terms of position between the European Court of Human Rights and the CRC precisely on this question of extraterritorial jurisdiction when dealing with other questions as the repatriation of children or jurisdiction of states in Syria, Iraq, and so on. So compared to the recent position of the CRC, the European Court of Human Rights is still, focused on its jurisprudence. So I do not know if the court is going to totally modify its interpretation to jurisdiction in light of the especially the Portuguese pending case. On domestic remedies, again, I go back to also what was said. We have actually, in the case law of the European Court of Human Rights, example of exception to exhaustion of domestic remedies included when there is absolutely no attempt from the applicant to lodge a complaint at the domestic level. We have the very famous, for French lawyers, it's a very famous case, Selmouni versus France, where the court said, okay, the applicant didn't try any of the procedural, judicial, criminal remedies available in France. But in this specific context, we consider that the exhaustion of domestic remedy does not apply. So it means that we have jurisprudence on the exception to exhaustion of domestic remedies, even when there is absolutely no procedural step at the domestic level. Selmuni was a case of torture, so of course, very exceptional situation, but it's not impossible to find precedent at the domestic level. So if the court may apply this Selmuni precedent, but again, the jurisdictional thing for me, it will be a tricky point for the European Court of Human Rights. So I'm not very optimistic on this jurisdictional aspect of the complaint.
Thank you very much. Professor Helen, any of the panelists? Go ahead.
If I can,
sorry, go ahead.
Yes, something short, because the European system has been able to protect the environment for years. For example, I remember the Lopez Oster case against Spain in 1990, if I will remember, through Article 8 on private and family life. What I think is that I am reflecting on the question, and I really appreciate this question about how the European system can also evolve. And I think it is time for international systems to break with the optics of artificial separation of human rights that comes from the Cold War. Hopefully, the European system can also evolve in the direction of the African InterAmerican regional system in relation to the effective recognition and protection of economic, social, cultural, and environmental rights, and not just through the indirect approach through the civil and political right. That is a good approach, of course. We still need this approach. We need all the approach to effectively protect human rights. But I think it's time to the European system to evolve in this sense. And also coming back to the domestic remedies, Professor Mesmour, I have a question, a curiosity, if you allow me to ask you about how did you consider the emergency posed by climate change when considering the domestic remedy issue? Thinking from a pro-person and pro-nature principle point of view, I think this is also a very strong point, as there is no time to lose. And I think in any hypothetical analysis from the InterAmerican system, that will be crucial. So I am very interested to listen about your possible exchange, if you are allowed to do that around this question. Thank you very much.
No, thank you very much for that point. I will come to it. I can come to it definitely. Professor Knox.
I was just going to, I think Soledad already mentioned one of the points I was going to make, which is that the absence of a right to a healthy environment in the European Convention has not stopped the European Court from actually building a quite extensive environmental jurisprudence. So the question would be, what would this new right add? I think the main thing it would add is it would make it easier to be able to bring cases for environmental destruction without having to tie them specifically to let's say, identifiable effects on particular human beings. So the, cases brought for the loss of environmental, amenities, the loss of nature, they would be easy to bring those kinds of cases. But I don't think anyone should think that this would in itself somehow revolutionize the European system, because I think the European system, frankly, has already been revolutionized. The objections to addressing environmental issues in the European Convention of Human Rights, the European Court has essentially already responded to that by creating an environmental jurisprudence. I don't think it's as clearly integrated as it could be, and perhaps this new protocol could help to do that. But I think there's already a lot to build on there. And I have to say, I regret this, but I have to go teach a class now. I don't regret teaching the class, but I regret that it means that I have to say goodbye now. So Thank you all very much. Thank you again, Benyam, for putting this together, and thank you to the other speakers and to all of the questions. They were very, very good, and good luck to all of us as we go forward. Thanks.
Thank you very much. Thank you for joining us, Professor Knox. Really appreciate it. Thank you.
You're welcome.
And we will wrap up in the next 10 minutes. So let me come to one point that was raised. We've had a bit of a conversation about exhaustion of local remedies. One thing that I want to mention is also related to the burden of proof, because the burden of proof of non-exhaustion exception is definitely on the authors. I think it's the same in the Inter-American system. It's the same within the Human Rights Committee. And I know for the fact that within the African human rights system, it's the same. So once the states have actually identified what remedies would be available, the burden is on the complainants. And my colleagues hopefully agree with me. From our discussion from this case, the authors didn't prove that the various available remedies at the domestic level would actually be futile. In fact, I hope I'm not bringing information that is very much from the closed discussions, but it was very clear from the discussion that even though the burden of proof of non-exhaustion exception is on the authors, the states actually even went further to explain how, beyond offering what was available, how what they are offering would actually not be futile. So they made a number of arguments in that direction. So it was difficult for us, legally speaking, to actually move beyond on the basis of the evidence that has been brought to our attention. I know that the point was made earlier that the committee had the opportunity and even had to be brave to make a pronouncement in relation to extraterritorial jurisdiction. Partly, we felt the legal basis was there. Partly, the argument that was provided by the advisory opinion was actually very solid. I also would be remiss if I don't mention this. If you look at the wording on jurisdiction from the Committee on the Rights of the Child, from the Convention on the Rights of the Child, and the wording in relation to jurisdiction that the Inter-American Advisory Court relied its opinion on, they're actually very similar. So that cross-fertilization, as it were, is not just for the sake of cross-fertilization. It actually has some legal basis. Otherwise, we would be, to a certain extent, the point, some states, they talk about mandate creep, like a delay creep. When you are about to board your flight, it says 10 minutes delay, and then when you go back, it says 15 minutes, and then it goes to 30 minutes, 1 hour. So there is they often make the argument about mandate creep under the guise of interpretation. And in this particular case, again, I come back to the point, in a situation where the complainants have not even tried, and there was no jurisprudence that they could actually rely on that could actually support the argument that if they had tried, it would be futile. In a way, as a committee, we felt our hands tied significantly. Now, let me come to one question that Liesel has raised here. And it says, how does the committee ensure that the decision is communicated to the authors in a child-friendly way and ensure that they understand why and how the decision has been reached? I'm happy that this question is being raised because the committee decided to actually do an open letter to the authors, specifically addressed and saying, Dear Chiara, Katerina, Iris, Raina, Radima, David, Rantan, Litko, Deborah, listing all their names. First, in relation to the case. Second, outline providing a simplified explanation of the case. We provided that. And then, of course, the reasoning that we followed in arriving at the final conclusion. So this is, I mean, there was a blog that our good colleague, Professor Ton Liefard, actually wrote about it from the point of view of access to justice, which we definitely welcome. But I'm sure there may be other examples, even from the Human Rights Committee or from the Inter-American system, that efforts are being made to make sure that complainants understand, in this case, children, why and how the decision has actually been reached. But if you want to add to it, please feel free to do so, based on your experience, if any.
You mean in terms of dissemination of
yeah. Or making it accessible, yeah, not for lawyers, but for the layman.
Yeah, no, and it was an excellent. It's an excellent question, of course, in terms of rights of the child. No, it happens that the Human Rights Committee, but it's not that quite often, I would say, but it happens at the Human Rights Committee, for instance, on specific cases, made some video to explain more concretely. We talked about implementation, what it means in terms of implementation, what were the claims raised. And we tried in this video, especially in I remember a case on sexual violence in Nepal, and we tried really to not use too technical vocabulary. We try to not to use, for instance, the specific provisions of the ICCPR, but more to talk about in terms of rights breached and what is the outcome and what it means for the state party and for the other state party. But I have to say, I have to admit that we do not do this in general. I think that the Inter-American system is much more in terms of infography and so on, much more advanced than the Human Rights Committee or treaty body.
Thank you very much. Ms. Munoz, do you want to come to it? Here is a compliment that is being given to the Inter-American system as being more progressive on this.
Well, we are thinking a lot on this, lastly, and the Commission actually in this recent period of session last week, we have been talking on Friday about the new strategic of communication strategy for the Commission, because we definitely think, and the Commission definitely think that we need to improve the communication to be most visual. As Helen said, we are using a lot of social network and videos and especially to arise and to be able to reach the young people in our continent. So I really congratulate the good practice of the committee. I read precisely this communication, this open letter to the request, the demanders. What's the name in English? Sorry, I forgot the name of the people that are demanding.
The authors.
Yes, the authors. Sorry, I forgot the name. The authors of the communication. It was really great, and I am interested, Professor Mesmour, to hear about the impact of this open letter regarding the authors, but also other young people, children in the world. Perhaps you can explain something else about this. Thank you.
Thank you very much. Yes, it would be interesting to know what the impact has been. Maybe it's premature, but I would like to believe, and I'm not quite sure how we can track that, but I would like to believe that the children have had access to it. A few of them have already turned 18. I have seen one comment on Twitter from one of the complainants expressing disappointment and so forth. I would like to believe that the open letter has been shared with all of them, even though there may be some, potentially maybe there may be some language related bias. It might be premature to assess, but let's hope so. We would like to believe that it's an important aspect of our work and moving in the right direction. We talk about the convention being a children's rights centered instrument. So they brought a case, it was important, we felt, and I'm glad that both the chair and the chair of the working group are here in this call, that decision was made by the committee to communicate along those lines. And of course, with support from our great secretariat. I feel that we're coming to an end, but I'm going to give and I will close shortly, but I'm going to give the opportunity to Ms. Mikiko Otani, who is the chairperson of the Committee on the Rights of the Child, and who kindly, despite the time zone difference, despite her absolutely busy schedule, actually decided to join us and stay for the whole almost 2 hours now. So I give the floor to Mikiko Otani. Thank you.
Thank you, Benyam. And actually, I enjoyed a lot of this discussion, as some of you mentioned that this kind of conversation among the academia is, and also actually myself is a practicing lawyer in Japan for over 30 years, but at the same time I have been doing academic work, and so it's very, very, very much stimulating. And I have to say, Benyam, can I use maybe 3-4 minutes?
Absolutely.
The
Absolutely.
conversation was so stimulating and interesting. So I just wanted to share some of my thoughts. Firstly, I'm from Japan, and Japan actually hasn't ratified any optional protocol or hasn't accepted any individual communications. So it might sound very strange, but Japanese lawyers who have been doing international human rights work have led many decisions of the individual communications from Human Rights Committee, Committee Against Torture, various treaty bodies, because we want to persuade the governments to ratify. So that's why we ourselves read and all the decisions and explain to the governments and share among the practitioners. So for me, it might be strange for you, but firstly, Japan is not a state party to the option protocol or anyone. And also, there is no regional human rights court or in Asia wide. And so that means that we are totally out of the regional human rights mechanism or court. But for us, the lawyers who do the international human rights work in Japan, it's very interesting to see how the international human rights norm has developed from regional courts, which will be which will have impact or influence in the jurisprudence of the other regional courts, or sometimes to the UN Human Rights Treaty bodies. So it's such a dynamic development of the jurisprudence and the norms of international human rights law. It's fascinating. So for me, it's not so much the question whether you can quote or refer, but if the subject matter is common and if the legal reasoning is convincing, you can use that legal reasoning. So this is how we see. I just wanted to share. So now I heard a lot of discussion, so I want to respond to some of the questions, maybe particularly from Helen, about domestic remedies. I try to deep into the understanding or the analysis of the domestic remedies issues. And I want to share some of the questions I had. So maybe we can discuss more the other day, because I don't want to prolong this meeting. Firstly, exhaustion of domestic remedies. So what is the implication of the extraterritorial obligation element to the exhaustion of domestic remedies? Firstly, I researched extensively the jurisprudence of Human Rights Committee, and I found one case. I forgot the case number. I'm sorry, I cannot share right now. But the case was the applicant was detained in, I think, if I remember correctly, in Iraq. But the state party is not other state. So the question was that this person, applicant, is in a very difficult situation to make application in a court of the state party against which the application was filed. That was the only case. The person, applicant, is outside the country. Of course, the high sea case is different, but this is rather old case. But there is no elaborate discussion about the impact of the situation where the applicant is actually outside the state party. So I think in the future, because the extraterritorial obligation is becoming more and more important for our work, maybe we can have some colloquium to discuss about the impact or how the extraterritorial obligation element would have the implication to the exhaustion of domestic remedies. secondly, the urgency. I also thought about urgency because this is the issue of urgent issue, climate change, and applicants are children. So how these elements, the applicants group, like children, and so for them, time matters a lot, and issue is very urgent. So again, I searched, and there was one case again of the Human Rights Committee. This I have a case number 747/1997. So in this case, Human Rights Committee said that taking into account the complainant's advanced age when holding that the application of domestic remedies had been unreasonably prolonged. So this is the one case I found that the Human Rights Committee actually looked at what kind of person is making a case. So this is just an open question, and I don't have an answer right now. But again, this second question about the children, how the fact that this is the children, applicants are children, would have an impact. Maybe this is more the question for the CRC. But the urgency, the subject matters urgency, is there any implication? The thirdly, effectiveness. And again, I think it's not just the Human Rights Committee, but also more established jurisprudence. For example, if the subject matter is deportation, so then even if the court has a jurisdiction to make a decision, but if the decision doesn't have the effect of stay, so then such a procedure is not considered to be effective. So in this case, maybe the exemption would apply. So I think, so to what extent, based on depending on the subject matter, such as climate change, global climate change, the effectiveness, or what is the effectivity would be a good question for us in the future. Before concluding, I just want to raise another question about international cooperation, because in this climate case, one of the feature of the arguments by the applicants was the international cooperation. They highlighted the importance of the international cooperation, not only by the applicants, but also the third party interveners also highlighted the importance of international cooperation. I think this is something we need to elaborate more in the future work, not necessarily for the OPIC or the individual communications, but also for climate change issue. So what is the international cooperation? And the applicants argue that the state parties not only to reduce their own emission from their territory, but also they need to persuade other state parties to reduce or have international agreements, more robust international approach they have to do through the diplomatic channel. So I think this is an important, very interesting questions. And how the international cooperation obligation comes up. Of course, international covenant, economic, social, cultural rights, Article 2 has such obligations, and CRC has international cooperation in Article 4, but both mention only to the economic, social, cultural rights. Is this approach we can accept now? We already overcome the dichotomy or division of the civil political rights and economic, social, cultural rights. We know now it's all interrelated and indivisible. So what does that mean that in the treaty, actually, the international cooperation is only mentioned in the context of economic, social, cultural rights? In this case, the applicants argued the right to life. So right to life, to when somebody outside of the state party or even in the state parties right to life is at the issue. So it's it, of course, maybe I have some objection, but this right to life is somehow categorized as civil political rights. I have some objection to that, I have to say. However, what does it mean? And I would say that are we thinking international cooperation only about the financial assistance or technical assistance? So that is why it is related to the economic, social, cultural rights to ensure and to fulfill or protect the right to life. What the state parties have to do. And I want to argue that it's not about only the financial or technical assistance. And I think we need to go back to the origin of this idea. United Nations Charter, the Article 55 and 56 talks about the separate or joint and in cooperation with the United Nations. So I think this is the origin of the obligation of the states to international cooperation, which covers actually everything, not just economic, social, cultural rights. And if you look at the International Covenant, Economic, Social, Cultural Rights, Article 2.1, it says especially economic and technical. So economic and technical assistance is just an example. It should be much broader. And I think this kind of issue, we found the very important questions raised in this climate change case. And I think we should continue the discussion and more discussion, maybe in this kind of colloquium or webinar, but also for the GC26. So GC26 is actually a very important opportunity for all of us. And I really appreciate those who are participating in this webinar would collaborate with us in the process of drafting GC26. Thank you very much. Sorry, Benjamin, for taking a lot of time, and I really appreciate you're giving me this opportunity to share some of the thoughts, because I was so inspired about by all the discussion today. Thank you very much.
Thank you very much for those inputs. Very much welcome. Clearly, this is not the first, this is not the last. Already, in fact, the stage for another webinar has been set in terms of some of the questions that we need to explore in moving forward. For instance, questions about technical assistance, international cooperation, arguments pertaining to Article 4. Does Article 4 actually establish a right, or it's just only a general provision? In fact, I will even go further and say that our jurisprudence in 2016, when we had the day of general discussion focusing on the environment, we actually laid quite a bit of a background work on children's rights and climate change and so forth. But even though our jurisprudence in the context of concluding observations has improved over the years, we've moved away, not just only Samoa, Tuvalu, Kiribati, and so forth, receiving concluding observations on in the environment. We've actually expanded it to other states as well, whether it's Norway in the context of international cooperation or other countries and so forth. Our jurisprudence, as Professor Helen said at the beginning, is also evolving. It's just only forming. And we definitely look forward to General Comment number 26, as the chair said, to help us bring this together in one document as concretely as possible. And even once the General Comment is concluded, it will still be an evolving one, because there are a number of more and more issues that are actually emanating. There was an article a couple of years ago from New York Times, which showed that a number of countries are actually outsourcing their carbon emissions. So they no longer produce some of these heavy carbon footprint materials. They actually produce them in another country, but import them into the country, which has a number of implications on extraterritoriality. So absolutely, this is just an initial conversation. We look forward to building on some of the points that were mentioned by our chairperson, but also some of the questions that came from the panelists. What remains for me to say is to say thank you very much to our chairperson once again for being able to join us, Professor Helen, Ms. Soledad, Professor Knox, for being able to be present with us and make the presentation. But also I want to thank our Deputy Vice Chancellor for Research and Innovation, who's been very kind enough to open the conversation. Last but not least, obviously the participants. And again, I acknowledge that our colleague, my colleague, and our chair's colleague, Professor Anne Skelton, is still with us in the call. But I also want to acknowledge the presence of Anna Batala from the petitions unit at the Office of the High Commissioner for Human Rights, whom we rely quite a lot in terms of the work that we do pertaining to the third optional protocol. Again, everybody, thank you very much. It was an absolute pleasure. Thank you for taking the time. And let's make sure that the conversation actually continues. As we started, we said we want to get the circle bigger, and this is part of the process of getting the circle bigger. Thank you very much. Have a good one.